Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Let's say that you own 50 acres of rural land. Maybe you go out there to go hunting. Maybe you have a pond there and you go fishing. Maybe it's arranged in such a way that you really can't see much from the road except the trees that sort of block the way. You don't even know there's a pond back there. Now, how would you feel if one day you went to your little 50 acres of land and you were going to go back and fish in your pond and you noticed a camera? And the camera was pointing at the pond. And it said, "This is the property of the government. You can't mess with it." What would you do? Well, you might think, why is the government spying on my land? Why do they care what I'm doing on my 50 acres of land? I thought that it was private property. I've got it posted. It says no trespassing. How did they even get in here to put this camera on there? Well, today we're going to have a little bit of a lesson in the Fourth Amendment. So in Tennessee, a couple of folks had rural property where they would hunt and fish, and they discovered that there were cameras on their property. One of them was in taking a shower when his wife came in and said, "Hey, there's a guy out there in the woods in camouflage that shouldn't be there." So he went out and went looking, and when he went looking, he found a camera. And basically that camera was put there by the Tennessee wildlife authorities, basically looking for people hunting out of season, poaching deer and other animals like that. And of course, this guy didn't have any affiliation with anybody who had ever poached deer. His land was properly posted, no trespassing. And all of a sudden, he had a government camera sitting on his land. He didn't think that was right. So he talked to a lawyer, and the first lawyer he talked to said, "Well, you've really got kind of a problem." And he said, No. I thought I had a Fourth Amendment right, to privacy and everything. And that's where the lawyer had to explain to him what the text of the Fourth Amendment says. Let's take a look at that now. The Fourth Amendment says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. So the key thing here is it starts with persons. It's persons, houses, papers, and effects. Do you see anything there about open fields in a rural area? And of course, you don't. But the Fourth Amendment has been extended a little bit further than that. There is a doctrine called the curtilage. And the curtilage is that area around your house. It can include your garage. It can even include a detached garage if it's close enough to your house. But the Fourth Amendment does not protect open fields. It's called the Open Fields Doctrine. It was first announced in Katz versus U.S., and then in Oliver versus the United States. Any doubts were cast away. Basically, Hester's reliance on the literal wording of the Fourth Amendment, because open fields are not effects, and distinguishing Katz, the court ruled that the open fields exception applies to fields, even those that are fenced and posted. And what that means is that while you have privacy inside your house and you have privacy inside your garage, you do not have privacy out there in the open field. The government can come and plant a camera there. At least under the Fourth Amendment, they can. But This case, which is Rainwaters versus TWRA, involves a bit of a wrinkle in this doctrine. And the wrinkle exists because the Tennessee version of the Fourth Amendment is a little bit broader than the Fourth Amendment. Let's take a look at that. Here's what it says: that the people shall be secure in their persons, houses, papers, and possessions from unreasonable searches and seizures. So, what is the difference between effects and possessions? Well, effects are pretty much anything you can carry with you. You know, your pocket lint is your effects, your car keys, that sort of thing. Your phone, your cell phone, for example, is probably an effect, and it shouldn't be searched without a search warrant. Possessions, however, are a different thing, because you can possess much more than just what you can carry. In fact, one of the things that courts always talk about when they're dealing with landlord and tenant cases is the right to possession of property. That's possession of property. And it's interesting to see how the judges on the Tennessee Court of Appeals deal with this issue. Let's take a look at that now.
This case challenges the constitutionality of Tennessee Code annotated section 70-1-305, which gives TWRA and its officers the authority to go upon any property and outside of buildings, posted or otherwise, while enforcing all laws related to wildlife. The plaintiffs filed suit seeking declaratory and injunctive relief that TWRA's entry statute is unconstitutional both facially and as applied, because it violates their rights under Article 1, Section 7 of the Tennessee Constitution to be free from unreasonable searches and seizures. It's the state's position that the circuit court's order finding the entry statute facially unconstitutional should be reversed because there is no justiciable controversy to maintain an action for declaratory relief, and the statute is not unconstitutional. First, with regards to the finding of a justiciable controversy, defendants contend that there is no live case or controversy here to give rise to a declaratory judgment action.
General, so is the argument you're advancing one of mootness in this case? And I mean, justiciability is an umbrella, right? So is mootness the particular doctrine that we're operating under here in considering whether this case is justiciable or not?
Mootness and possibly ripeness, Your Honor, since there were past entries on the property, but at the time that the lawsuit was filed, there was no entry in over a year and a half.
The state maintains that the action being engaged in here is constitutionally permissible. If the state is maintaining that position, then how, under the Norma Faye Piles case, can this action be regarded as moot? If the state's saying, look, we did it, we think it's constitutional, we do it again, how can this action be one that's viewed as moot?
I'm not familiar with that case right offhand, Your Honor.
If I had one piece of advice to give young attorneys, new attorneys who are just starting out in the area of appellate advocacy and oral argument, one of the things that I would tell them is to reserve procedural challenges for the end. Because when you waste your time advancing a procedural challenge, and it's a tenuous procedural challenge, all you're doing is using up the time that you would have to argue the principal part of your case, arguing something that you ought to know up front that you're going to lose. Now, this lady is saying, this is moot because we moved the cameras. There's no controversy anymore. But as the judge points out, it is capable of repetition and yet evading review, because the next time they get sued doing this, they'll just remove the cameras and say, hey, there's no justiciable controversy. And that's not going to fly. The judge here with that big bushy beard may look like he, just wandered in off of the North 40, but the guy's brilliant. He has a really good approach at this particular oral argument. So let's get back to it.
With regard to the substantive question, the Article 1, Section 7 question in this case, possession seems like the key textual word that we're wrestling with here under Article 1, Section 7. Why isn't an individual going on a walk in the woods, camping, hunting, why isn't that a possessive use of rural property? Isn't that an appropriate use of rural property to go for a hike in the woods, to go hunting, to go camping on it? Isn't that something that makes it a possessive use rather than wild wastelands?
I think the line of cases that were cited in the briefs really show that the courts look to the specific area where the entry or the contraband is found to make that determination. And it really depends how close in proximity you are with regards to the occupation or any kind of residence on that property to decide. So kind of an analogy is you have 100 acres of property and maybe you're only really actively using 50 of those acres and the other 50 is wild or wastelands. So the fact that you use that 50, does it bring the whole 100-acre parcel into a possession under Article 1, Section 7? I think that's what the line of cases shows, that you really have to look at the specific area.
Does the record provide a clear delineation showing that the entries were only in areas where the homeowners or property owners were not going hiking, weren't hunting, weren't going camping? And does the record establish one way or another whether the particular areas of entry were those where those activities were not occurring, or whether they were areas where those activities were occurring?
I think the record shows that the areas where TWRA was and where they entered are areas open where hunting is taking place, which is why TWRA was entering the property to begin with. And
if hunting is occurring in that place, why isn't that an appropriate possession use of rural property? And if it seems like that's something a lot of folks would do with rural property in the state of Tennessee, is go hunting on that property. Why isn't that something that makes it a possession rather than wild wasteland? I mean, the person's putting it to use, right?
I told you this judge was smart. He has hit the nail on the head with regard to the question at issue in this case. That's a possessive use, a possessory use of the land. And eventually that is where they come out. The rest of the argument is essentially the plaintiff, in this case, the people who sued the government. That's essentially them cheering on the Court of Appeals justices saying, yes, Your Honor, you are absolutely right. I'll spare you the rest of this oral argument because oral argument is something that interests lawyers and we like to watch it. I've had people tell me that it's as dull as watching paint dry, so I will skip that for you. This is an interesting case, and this is another one of those cases brought by the Institute for Justice. And they are doing the Lord's work out here, let me tell you, in terms of establishing privacy rights and pushing constitutional boundaries in favor of privacy. So I point that out because I believe very strongly in what they're doing. And even though I don't necessarily believe so strongly in all of the cases that they're doing, they have the right to pick and choose the cases that they want to take on. And I salute them for the cases that they have taken on. So if you have any questions, the full oral argument is out there on YouTube. You can watch the whole thing. And although I haven't yet seen an opinion, my understanding is from news sources that the Court of Appeals has essentially ruled for Terry Rainwaters. And I think that's probably a very good thing. If you have any questions, put them in the comments down below. Like, share, subscribe, you know all that stuff we ask you to do. You can also email me if you want to. If you have the opportunity today, just do something nice for somebody. And then catch me down here at the beach again next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.